Hello friends, again I am here bringing part 2 of the video showing the roles and the rights of the charged official to whom the disciplinary authority has served charge sheet under major penalty. How to defend it? I have already explained the same in the part 1, where up to the submission of the document, up to the before conducting the prosecution witness and the defense proceedings, what the duties, I have covered it in the part 1. So I would request you to see part 1 also while you switch over to the part 2, which I am going to explain. See this video right from the start and till end, so that you can fully understand your rights and what you are to, how to defend yourself. This is the very important part. So coming to the subject, the inquiry officer now has issued the orders to start the inquiry proceeding on the fixed date time, right? So on that day, the CO, the prosecution witnesses, presenting officer will appear, because prosecution proceeding will start first. In the inquiry process, first the prosecution put up his case, then after finishing the prosecution proceedings, then the opportunity is given to the defense side, right? So first let us start with the prosecution proceedings. So on the fixed date, they will appear and prosecution proceeding will start. So during the process, the IO will ask the presenting officer to put up his case. So he will produce the document, listed document, one by one through the prosecution witness. So the maybe 1, 2, 3, 4, it depends upon the case, how many prosecution witnesses will be there. So he will try to establish the charges, record the statements, and signed, and based upon the document, one by one it is produced before the inquiry officer. Now while taking those documents on the record, the inquiry officer will mark it in the exhibit P1. P1 means prosecution, P1, P2, P3, P4, like that. And the statements of the prosecution witnesses will be marked as prosecution witness PW1, prosecution witness 1, prosecution witness 2, prosecution witness 3, like that. Like suppose first prosecution witness has finished his statement, then the charged official, he will cross-examine that prosecution witness. So my request to the CEO is that while recording the statement of the prosecution witness, you must be very alert and note down the points which you need to ask him again after the statement of the prosecution witness finishes, right? So that is called cross-examination. So you will ask very piercing question which you think that those are very good for your defense, right? No. So those, whatever objection, whatever the examination, that also be recorded. That is called cross-examination. Now after cross-examination, the presenting officer, if he is alert enough, generally they do not do it, but if he is alert enough, then the presenting officer will again re-cross-examination. Whatever you have inquired from the PO, he will try to cover it up. That is called re-cross-examination, right? So after re-cross-examination, there is another thing. If the IO has any point for the clarification, for the sake of clarification, he wants that some clarification should be there, so he can ask the prosecution witness that explain, and that will also be recorded. So the statement of the first prosecution witness is over, everybody will sign, and that is taken on the record as PW1. Similarly, PW2, PW2, 3, 4, like that, right? So once the statements of all the prosecution witnesses have taken on the record, all the prosecution documents have been produced through the prosecution witnesses by the PO, then the officer will declare closure of the prosecution proceeding. Thereafter, the prosecution will say nothing, right? So he will contest the defense, but he cannot put up new document or something, or prosecution he cannot, right? So no prosecution proceedings are closed. The IO will issue the orders for defense proceeding. He will fix the date, time, and so on that day, and defense proceedings will start. Now, what the defense proceedings are? The defense assistant, I again and again stress upon you that if you know the subject very well, only then you contest your case yourself. Otherwise, please have the defense assistant on your behalf. He will not hesitate to ask the question to the IU or to the presenting officer or the prosecuting witness. So make it a point that you should have the defense assistant to contest your case. He will produce the document charge wise to cover the each and every charge through the defense witness, right? And if, statement of the defense witness will be recorded, right? Those statements are taken on the record as DW1. See, defense witness 1, defense witness 2, defense witness 3, and the document and regional document, whatever the defense assistant will produce to the inquiry officer, those will be taken on the record as next D1, next D2, next D3, like that, right? So till end, maybe in 2-3 sitting, whatever according to the length of the case or the charges, the inquiry will go on, defense go on. Now again, here I say, during the inquiry proceedings, in between you again feel that some additional documents are required. First you have taken the defense document, right? Then additional document, but still you feel that some additional document. Gentlemen, that's your right. You can give a writing to the inquiry officer. Yes, during the proceeding, I feel that such and such additional document I require to defend my case. So he will postpone the date, fix another date for the same, and somebody will come on behalf of the management bringing the additional document to produce on the day of the proceedings. Statement of the defense witnesses are recorded. Defense witness statement is over. Now the PO will cross-examine. After cross-examining, the CO can re-cross-examine to cover the point in his defense. Third, the IO will has the power to ask any question for his clarification. So when both proceedings are completed, see the prosecution proceeding and the defense proceeding, then the proceedings will be further process proceedings will be closed, right? And the IO will submit will issue the orders to both presenting officer and the CO to submit the prosecution brief and defense brief, right? So they are given the date, time up to which they are to produce the brief. Officer. First, the presenting officer prepare his brief, okay, prosecution brief, and submit it to the IO. Now, IO, after getting it from the presenting officer, the brief, he will pass it into the CO for his comment. So CO will examine it, right? And whatever the comment he want to give to in his defense, so he will prepare defense brief, right? DA, the defense assistant will prepare it. Those are submitted to the IO. Then IO further examine both defense brief as well as the prosecution brief. Based upon the prosecution brief, article charges wise, he will prepare a report and submit it to the disciplinary authority with the defense brief, with the assessment of evidence of each article and his findings as to whether the charges are proved or the charges are not proved. Third stage, suppose there are 5 charges, so out of 5 charges he will say 3 charges are proved and 2 are not proved out of 5. So that is partially the charges are proved. He will conclude it. So that report will go to the disciplinary authority. Disciplinary authority will further send again that report, prepared report of the IO to the CO. Look, that you are right. Sometime it came to our notice, sometime the report is not sent, IO report is not sent by the disciplinary authority to the CO. He unilaterally examine it and give the punishment. No, it is your right. So when the report is received, IO report is received to you, please examine it, and wherever you want to say something, give additional document also, or you say yes, article wise, go deeply into the subject and refute the charges if it is refutable, right? Then your reply will be examined by the disciplinary authority. Now, disciplinary authority can take 2-3 C action on that. First is, after getting your C comment on the inquiry report, if he is convinced that charges are not proved, so he will exonerate you, number 1. Number 2, he will say that the charges are partially proved, 2 or 3 out of 5 as I told you, 3 or 2, and he will impose the penalty. Now, third, if he is convinced that the inquiry report is not clear to his mind and he wants further inquiry, so he will resubmit again to that inquiry officer. Look, I am not clear about such and such articles, such and things. You please re-inquire it and then submit the report. Right. So the IO again conduct the inquiry in the same way as I have told you. Then the submit the report. So 3 things I have told you. Fourth condition is that taking all the things into consideration, the disciplinary authority does not agree with the findings of the IO. So he passes a disagreement note on the file saying that here point 1, point 2, point 3 charges I am not convinced. Okay, so I disagree with the IO. No, point is that if he disagree with them, what further to do? So he will send the disagreement note charge wise, those charges where he is not in agreement with the IO. So he will send it to the CO, charged official, for his comment. Now, the CO will examine the disagreement note and try to defend himself, article wise, charges wise. Then submit his comment to the disciplinary authority. Disciplinary authority will consider your reply, and if he is convinced, okay, fine, he can go for the penalty, he can go for the exonerate you, or whatever the decision he takes, that is up to him. So whatever the orders he will pass, those will be communicated to the CO. So gentlemen, this was for one person. Suppose there is only one CO. See, he has engaged into some activities which are objectionable activities. So he is one. But there are cases where multiple COs are there. So in FC I have seen that 30 COs are there and 20 COs are there. What to do? So in that case, disciplinary authority has the power to advise the inquiry officer to go for common proceedings. What are the common proceedings? Common proceedings are that every CO have the right to have his defense assistant. Every CO has the right to bring his own defense witnesses, right? And But inquiry proceeding will take in one room together while recording the statement of the prosecution as well as the defense witnesses. So everybody has the right to ask the question. Cross-examination, cross-question, re-cross-examination, the same way as I have explained to you. So those are called the common proceeding, and based upon that common proceeding, the IO will submit the report to the IO. So this was all about the your rights, gentlemen, which I was thinking that it must be. So when the disciplinary authority has the right to charge sheet you, then you should have the right to defend you in an honorable manner, and you should know the text. You should know the in and out of the inquiry. Kindly again, I'll say, see it with the part one so that you can have the full see gist of the this disciplinary action, how to defend yourself. Thank you very much for listening to me. Again, I will request you, if you have liked this video, please put a like, push a like button, and try to subscribe also, and pass it to circulate to your friends so that the people who are really suffering. And in addition, if anybody wants my help, kindly note down my mobile number. You can ask me day and night. I am available for the advice. 9677 111 000. Again, I am telling you, 9677 111 000. Thank you very much. God bless you.